And the Australians, when they drafted the Constitution, had in mind not just the American Constitution, but the practice of judicial review that had been established in the United States, at least since Marbury and Madison, which is a case I'm sure you're familiar with, which established the notion of judicial review. And so the Australians expected the High Court to exercise judicial review in virtually the same way in which the US Supreme Court does, as well as any court. So it's accepted or assumed, just like Chief Justice Marshall in Marbury and Madison said, that it's the task of the courts to say what the law is. And when you have a written constitution which declares the law, and you have a statute or an act, the Congress or a parliament, both of these purport to be law, and it's the role of the courts to determine what is the law when there's a conflict between the two, and on the supposition that the Constitution is intended to be a superior law, it prevails over the parliamentary or congressional statute, and the statute is declared void or invalid and of no operation. So the High Court of Australia exercises that constitutional function like the US Supreme Court and raises similar sorts of issues. And so just like in the United States, and I appreciate it's an old debate and perhaps a tired debate about the legitimacy of judicial review, the question of the legitimacy of an unelected judiciary striking down legislation enacted by democratically elected legislatures. So we have that sort of a debate in Australia, even though it's well accepted that the High Court has this function. But that debate then is the backdrop to arguments about the legitimacy of particular decisions by the courts when they strike down legislation, and about whether the grounds upon which they're striking down legislation can be justified by reference to the Constitution or not. So there are those similarities in debates that occur across the two countries. A couple of other things to just note. Just like in the United States, the High Court of Australia has tenure, although there's a compulsory retirement age of 75 for our judges. So they must retire at a certain age, whereas yours have life tenure. And one other important thing that's different about Australia is that there's a closer relationship between our state system of courts and our federal system of courts. And this is due to two things. The first one is that in addition to its constitutional jurisdiction, the High Court of Australia has a general appellate jurisdiction, meaning that it hears appeals from the state Supreme Courts, the Supreme Courts in each Australian state, on not just constitutional matters, but matters of general common law. And what that means in Australia is that it's very clear that there is a national common law. And you really can't conceive of the common law of a particular state as if it was distinct from and different from the common law of another state, which is quite different from the terms of the debate here in the United States, and the question about whether there could be a federal common law, and the tendency to take the view here that common law is the law of each state. So that's an important distinction between the two systems, which casts a lot of responsibility on our High Court because it's both constitutional and also in charge of the common law of the whole country as well. And the other thing that ties our federal and state judicial systems together closely is that under the Constitution, the framers decided to enable the Parliament to confer federal jurisdiction directly on state courts. The idea being that it might not be necessary and it might be difficult logistically to create a full system of federal courts below the High Court of Australia. And so and here's a large word, the autochthonous expedient, the homegrown idea in Australian constitutional law was to vest federal jurisdiction in state courts. And that means that a state court can hear federal matters, and of course its decisions in those matters can be appealed through the federal court system. So we have a more closely unified judicial system than you have here. So that puts the High Court into context. And there's one last thing that's very important to place it into its context, and that is that Australia does not have a Bill of Rights or a Charter of Rights. And it's just about the only country in the world without one. Some of the states or territories do have charters of rights, more or less modelled upon the Canadian system, and I won't expand on that, but some of you may know how the Canadian Charter of Rights operates. But there's no federal Bill of Rights, there's no national Bill of Rights. And that means that the High Court, when it's making constitutional decisions, is for the most part not making rights-oriented decisions. It's not striking down legislation because it's contrary to some individual or perhaps a group right. Its decisions tend to be focused on federalism issues. Like your Supreme Court, our High Court deals with questions of the legislative competence of the federal parliament that corresponds to your Congress, as well as the legislative powers of our state parliaments as well. So there's not too much in the way of rights jurisdiction, as it were, that's exercised by the High Court of Australia. Except there are just a couple of small exceptions. There are a few scattered guarantees of rights in the Australian Constitution. And I think the most interesting, well, one of the ones that's interesting to me at least, especially for comparison to the United States, is the Australian Section 116, which contains a guarantee of the free exercise of religion and a prohibition upon the establishment of religion in the country. And very interestingly, like your First Amendment, the wording is very similar in referencing free exercise and non-establishment, and also is similar in that the Australian provision prevents the Commonwealth Parliament from making any law that would interfere with freedom of religion or establish a religion, but does not bind the states. And that continues today, it has been affirmed by the courts in Australia. And there's no 14th Amendment or jurisprudence associated with the 14th Amendment in here, which would, to an extent, though controversial in for some people, take the Bill of Rights here and apply it to the states and say that the states are bound by that. That hasn't happened in Australia for the most part. The other interesting thing about Section 116 was it's deliberately adopted from the First Amendment. But of course it only took the religious clauses or religion clauses from the First Amendment and not the other clauses. For example, free speech or freedom of the press. So that there's no explicit guarantee of free speech in the Australian Constitution. And yet Australians enjoy freedom of speech. In fact, I think I could argue that they enjoy at least as much freedom of speech as you do here. Maybe even more. So an interesting paradox, if you like. The Australian polity has not been brought up on the thought that fundamental freedoms have to be guaranteed by the courts. And that's part of the reason why Australia still has resisted adopting a Bill or Charter of Rights, even though just last year a major inquiry commissioned by the federal government looked into that very question and has recommended that Australia adopt a Charter of Rights. Again, along the Canadian lines rather than US lines, and I'm going to try and explain the difference in the time that I've got available. I don't know whether, though, the federal government is going to accept that recommendation or not. We have yet to see what will happen. I've got a bit of an inkling, but I don't know just yet. Nobody really knows for certain. So, in that context, I want to just say just a few things about some of the Australian cases, especially in relation to federalism and rights.